may look at it as some kind of an infringement or some kind of a threat to the power that is being exercised by them. So therefore, so what is the text really speaking? Because when we are looking at various authorities, and all of them have, I have no doubt in my mind at least, all of them have very, very, very important functions, very important people, who are carrying out those functions. But the approach should be to actually move from this subjectivity about what one feels about cooperation, as Mr. Singh had pointed out, that there is hardly any, or even Mr. Rakesh now, there's hardly any communication between the regulators. So instead of leaving it to the subjectivity, I think the need is to create a framework, the framework that defines that how and in what manner should various authorities or regulators engage with each other, because that can provide the framework of convergence. There are of course two views. So for example, if I can refer to the Verizon Communications judgment of the US Appellate Court, where the issue was with regarding to who will exercise the competition jurisdiction. Is it the department in charge of telecommunications, or is it the competition authority? Where the Court of Appeal said that if there's a regulatory framework which is already existing within the Department of Telecommunications, which can address the competition issues and the remedies effectively, then you don't need a competition regulator out there, because the value addition will be very restricted. The other way, the other approach that we look at is, some of the, memorandums of understanding that have been signed between the CMA, that is Competition and Markets Authority in UK, with Ofcom and Ofgem. Very, very, very detailed kind of, memorandum of understanding, where they lay down a certain, qualitative guidelines, I would say, in terms of the role of the authorities when they are getting into a cooperation, the aim and objective of carrying out a cooperation, why are they getting into this cooperative mode, the basis for allocation of cases, the procedure to be followed, and how to share information. Now, taking from this, I think what I'd like to point at is there are 4 areas that I look at in terms of when I look at the question of how or why should regulators and the CCI think of working together, who is going to differ. It's really not a question of overlap, it's a question of gradually coming to that convergence. So going from Mr. Rakesh Nath's topic, so I talk about open access. The Electricity Act provides for something called an open access. That same concept applies under the Telecom Act also. The same concept applies to the Petroleum and Natural Gas also under the PNGRB Act. Open access is basically a concept where you're allowing your network or your infrastructure as a carriage to be used by various utilities for transferring their content through it. So it's basically a usage of a carriage for the purpose of transportation of content. Now, electricity, and Mr. Rakesh Nath, I think will agree that we have seen a host of matters where, basically utilities or consumers have been asking for open access from various state authorities. And the state regulators, just to give you a brief background, in Electricity Act, you don't have one regulator, you basically have 25. So one for the Central Electricity Regulatory Commission, which deals with interstate issues, and then there are state regulators for every state. Now the state regulators have their own agendas. They have to ensure that the bulk of the high-paying consumers actually are captured by the utilities who are serving the state, because that is the money that has to be used to actually, provide for the certain amount of cross subsidy to the low-end users who form the major bulk of the, consumers in the state. So therefore, the turf war is on open access. So if a bulk consumer tries to get open access, there have been many occasions where the state utilities, or even in some cases the state commissions, have willy-nilly tried to, cut out that open access. Now, if you are looking at how to address this issue, probably the Electricity Act is not the best act, because even if you are looking at penalties, even with the new the amendments, which of course have not come, even under the amendments, the amended amount of penalty was up to 5 crores. Today it is only 1 lakh for an infringement. So therefore, if an utility is trying to abuse its dominant power in terms of having that carriage, there is hardly any deterrent. This is one of the areas where probably the Competition Commission will be more effective in terms of creating that deterrent effect by imposing these, the fines that would put the utilities on their, on their guard, that they cannot really, deny this kind of open access. But for this also, there also needs to be an understanding of the sector. One of the other things I also wanted to point out is, as Mr. Machendranathan has pointed out, the ERA does not have any competition powers under the Act. And so therefore, while it is looking at determining the airport tariff on the aeronautical side, what it can't look at is how are slots being allotted to airlines, because there are a host of issues that can arise out of providing slots to airlines, providing parking lots, preferential parking lots to certain line of cabs, and there have been decisions on this also. So this again is a form of abuse of dominance, and mostly it's abuse of dominance because generally regulated entities are entities which have a natural monopoly. So therefore, if a regulator does not have that power, then who has to address it? It's obviously the obvious answer is the Competition Commission. But the question also is that how does the Competition Commission get into the nitty-gritties of the sector? Because it becomes very important to understand the market structuring, the market dynamics, and also the economics of the particular sector. Because without understanding the economics, you cannot get into the sector. I'll give you a very simple example. Let us say you have London Bridge. Of course, London has a lot of bridges, but you have London Bridge, and there's some man who there's some company which is kind of let us say that there's a toll on London Bridge at any point of time. It is not there, but let's say it is. So there's a competitor who comes and says that, look, and let's say there's a regulator for bridges also, and he comes and says that, look, why can't I build a second bridge? I'll also collect tolls. Really speaking, the economics may not actually allow you to build that second bridge, because ultimately, once the traffic gets diverted into two, then the cost that you're recovering in terms of each of the developer may not be sufficient to recover the cost of that bridge. So therefore, you have to look at how the economics of the sector works. This is a very, very, very rudimentary kind of an example, but so therefore, understanding the economics of especially of regulatory sectors become very important. Which comes to the second part, that is the knowledge of the sector. Once they have the knowledge, then becomes the third part is how do you apply that knowledge? A sector regulator may be having all the information, but does not know what are the economic techniques that have to be used by a regulator or an antitrust regulator to actually identify and address competition issues. So therefore, you need the know-how and the infrastructure also. And all this is ultimately relevant to address the asymmetry of information that various authorities have. So at the end of the day, I think what one has to look at is the idea of convergence and develop framework so all the regulators and CCI can sit together and discuss issues across the table and try to identify issues. Thank you. I think I will leave with that thought.
Before opening it up to the floor, if there are any further comments from the panelists, I'll just raise one. Mr. Nath, I wanted to ask you, why can't we as consumers have a more meaningful sort of choice in who we want to go to for either electricity, cheaper electricity? Why can't cost be brought down there?
See, the Electricity Act provides that the state commissions have to make regulations to provide open access to distribution system. Say up to 1 megawatt capacity within a time frame of 5 years from the enactment of the Act, say for example up to 2010, at least 1 megawatt capacity consumers have to be provided open access. But it also provides that the open access, the consumer will have to pay the cross subsidy surcharge and the wheeling charges for use of the distribution system and additional surcharge if any. Now this cross subsidy surcharge is to compensate the distribution company for the loss of cross subsidy that the subsidizing consumer is providing to the subsidized consumer. And the wheeling charge is the use of charges for the use of the wires. But there is one more thing, that is additional surcharge, and that is to be levied only if there is a stranded capacity. Some capacity is stranded because of the open access granted to the consumer. Now, most of the consumers, most of the distribution companies have tied up long-term contracts, and they are able to show that they have surplus capacity, they have tied up capacity to meet the demand of all the consumers. So if this consumer is going out, he will have to pay the additional surcharge, which will be the capacity charge of the standard capacity. So all these charges add up, becomes quite heavy. So far, this cross subsidy surcharge and wheeling charge used to be about 1 rupee, 1 rupee 20 paisa, 30 paisa. And the market price going to 2 rupees 50 paisa, it was viable to take power by the consumers, and the ultimate cost to the consumer was coming out to be less than the retail supply. But now with this additional surcharge, which is again another 1 rupee 20 paisa or 30 paisa, it becomes unviable. So that is the main problem which is coming, and these are the provisions of that. Now the method in which you calculate these charges is something which regulator has to really see and decide objectively. Now, unfortunately, that is not being done because, as rightly pointed out by society, that the state regulators particularly are a little more influenced to see that the distribution company, the state distribution company, also are engaged somehow in business. So that is a big issue. So even though there is cheaper power available. And another problem which is coming, you see, the market, the rate of power has come down, but still that is not being passed on to the consumer. That is because the distribution companies have tied up long-term contracts with generating companies who are uneconomical. For example, a state generating company set up a power plant in the state. Now it may have very high cost. For example, in Delhi Commonwealth Games, they put up huge capacity around it. Now all that capacity is now stranded because that cost of that power is very high. One of the power plant was a 800 megawatt gas station, a 1200 megawatt gas station. There is no gas, but the fixed cost of that is being paid by the consumer. So they are keeping these projects down and import and buying power from the market at a cheaper rate. But the fixed capacity of those is to be borne by them. So it's a very complex situation. So ultimately, when the distribution company, when the regulator is approving the power purchase agreement with this long-term contract, that time somebody has to intervene. Somebody should go to the competition commission and say that this should not be allowed. Even today, when power is available in the market at cheaper rates, many regulators are allowing procurement of power to the route of Section 62, which is cost plus tariff, which will work out to be much more costly than what is available through a competitive bid.
Any questions from the audience? Please introduce yourself and your affiliation. We can't hear you.
Hi, I'm Zenia from Veritas Legal. While I do appreciate that there is a need for synergy between regulators, how exactly would you address like specifics? For example, the concept of control is understood very differently by the CCI, it's understood very differently by SEBI. Under the Companies Act, it's defined in a different way, and for the purposes of FEMA, it will be understood to mean something differently. So how would you create those synergies, and how would you get that all streamlined?
I think different laws have different objectives. In competition law, by control we mean control over the market. In securities market, we mean control over an enterprise. If we just believe in these two definitions, then there is absolutely no ambiguity. The ambiguity arises because under the competition law, we try to look at control over the enterprises in the same manner SEBI looks at control over the enterprises. Competition law is essentially meant to look at the control over the market. I will give you an example. The market for the transport services, Ola and Uber. Just one entity has merged the market of 55,000 taxi owners without merging the entities. So there is no control over the entities, but market is merged, one person has taken control over the entire market in Delhi. So if you move away from that concept, look at market, control for companies, then there is no issue because the objectives are different. When you talk about securities market, the objective is to protect the small investors, minority interest holders, minority shareholders. Here the objective is to protect the consumers. Here the objective is that nobody should be in a position to have any appreciable adverse effect on competition in market. So if you, as long as you try to confuse these two meanings, you will be a problem, and we prefer to live in that confusion.
Good evening, I'm Rakesh Kumar, and my question is directed to Mr. Rakesh Nath. Sir, you opened your talk with saying that the Electricity Act aims at increasing competition in the market. However, during the discussion, I got this impression that each vertical of the electricity segment is controlled by the electricity authority, be it the state one or the central one. Now, towards the end, you said that even the surcharge amount is determined by the regulator. Now, my basic question as a student of economics is, I understand competition as easy entry and exit of players, a condition in which prices are fixed by markets. So, my very basic question is, what are the parameters of competition that the regulator, the electricity regulator refers to when it talks about competition? And how an assessment has to be done whether competition has increased or it has gone up? Thank you.
The power procurement cost constitutes about 70 to 80% of the total tariff that a consumer pays. So I think the major thing which is to be controlled is the power procurement cost. The regulator, the state regulator, has the power to regulate the procurement process of the distribution company and also the rate at which the distribution company takes the procures the power. Now that is one area where the regulator has to see that the power tied up by the regulator, by the distribution company is at the optimum rate. Now there are two methods which are available for procurement of power. One is that they enter into agreement on, and the tariff of that project is determined by the commission on cost plus basis, on the capital cost and giving some return and normative operational parameters. That was being used earlier when their power was deficient. Now with the private sector coming in a big way in this power sector, now the availability has increased substantially. Now the second route available is through competitive bidding. So you invite competitive bid and you procure power like any commodity. Now this is the area where the regulator should see that the power is procured optimally. Now unfortunately many of the regulators have not done their job properly, and this has resulted in a number of uneconomical projects coming up, and the distribution companies have tied up long-term contracts with them. But I think in future, the incremental power should be bought through competitive bidding, which will help in reducing the overall cost to the consumer. The second component is the inefficiency of the distribution company. That is the aggregate technical and commercial losses. The what you call theft in the electricity sector. Now that is one area where we have not been able to do much, because bulk of the distribution is controlled by the state sector. Unless we have private sector in this area, and we have very efficient private companies operating in some towns where they have been able to reduce the losses to international level, 4 to 5%, whereas we have other areas where we have losses of 30 to 35. So all that is being borne by the consumers. So this is one area where regulators should allow competition, because there is already a provision for providing more than one distribution company in an area, and that should be properly utilized.
So may I just add to that? I beg to differ a little from Mr. Nath. We have seen quite a bit of competitive bidding on in the power sector in the last few years. My view is a little different. I think the way the bidding has gone in at a certain level have actually created either non-viable projects or projects with extremely inefficient technologies, because ultimately when you bid at a price, the bidding is done on your per unit tariff. So that has to be kind of matched with the investment that you make for the project. Now if you bid something like a 1 rupee per unit tariff or 1 rupee 10 paisa, then obviously you can't be going for the high quality technology that is available and good quality products that are available. So therefore it can be looked at from both angles. Really speaking, a lot of the projects which had been bid out at a certain point of time have not even come up because they're obviously non-viable. The question is, how mature is the market? How mature are the bidders? That's probably the other aspect which also needs to be looked at when one is introducing competition in certain areas.
I think as far as the technology is concerned, if you take the ultra mega projects, Sasan and Mundra and Adani Mundra, I think technology wise they are not inferior to any project. You see Punjab projects which have come, they are also very modern, very high efficient. Most of the problems have come because of the unforeseen issues. It is very difficult to make a perfect PPA for 25 years. Because we have gone for a long-term event. And 25 years, nobody can foresee it. Two things have come up which have affected like the Indonesian regulation has affected the Mundra project. It is not something which was foreseen by anybody. If anybody had foreseen that particular thing, then probably it could have been built in the bidding documents.
Any other questions? We need to be quick because we're coming to the close of the session.
Good evening, everyone. I'm Abhinav from HSA Advocates. And my question is to Mr. Kuldeep Singh. So, considering that the crux of the discussion in this house was that the collaboration between sectoral regulators has, so to say, I don't know, feel of significance that we need this. What, apart from the possible conflicting interplay between legislations, is a hurdle due to which this collaboration hasn't played out as of today, or due to which the standard of that collaboration is not what is satisfactory to us? And in essence, why I'm asking this is because how do we foresee this collaboration playing out in the future? Between the sector.
Time to switch off your lights.
But I don't see any conflict in the legislature as such, because now both the CCI as well as the telecom regulator can make references to each other, whether in the course of proceedings or whether through also. And if they find that after seeing the opinion of the other parties, if they find that this is better handled by the other, they can definitely do that. Yeah, one thing the legislature can provide is that sometimes if they need the help of each other, maybe that is not very explicit in the listing. Supposing they ask for opinion is given. But in the course of proceeding, if they need the help of an expert or some members who can help them in understanding the issues, probably something can be done there. But there is no conflict as such which I see. Regulators were essentially created to do it. What we are talking about, section 21A is a reactive. 21A says that whenever a proceeding is before you, that generally means whenever an enforcement proceeding is before you, then you consult another. There are many problems while a proceeding is on, you consult another. But where are the competition issues? Competition issues are the measures you take proactively. When you lay down, let's say, I give the example of continuing professional education requirement of ICAI. That is anti-competitive but not illegal. So if you bring them to engagement tables on proactive issues, it will be useful. CCI is now considering that whenever a government or regulator comes up with a new legislation, bill, regulation, something like that, CCI proactively will assess it from competition perspective and share its views with the authorities concerned. It's for authorities to reject it, consider it, and throw it away. That is the only way, because for example, take the example of subsidy in LPG. Government's objective is that we want to support poor people. But if Competition Commission could have told that the same objective you can achieve by giving direct revenue transfer, which is a neutral, which does not disturb the choice of people, that is a proactive engagement. Section 21 is a reactive engagement, that is why it does not work.
If I may add something very quickly to that, there is another thing now. It is not only in the course of proceedings. Supposing now Internet of Things is coming, where the various things will be getting connected together. Machines will be getting connected to the Internet, and they will be controlled by the remotely. Now, if the regulator is thinking of laying down standards tomorrow, and they are not sure whether these standards
will lead to some anti-competitive, how many people will be able to meet these standards and whether there will be enough competition or not. Even if there is no proceeding taken, you want to refer to the commission and commission can look into this aspect. So technical aspect, standard is one thing, but the effect on the competition, they can always seek the advice of
I want to thank the panelists. Thank you very much, sirs, for your insights. And I want to thank the audience for being here. I think it's time to go and have some tea and coffee.
Good evening, everyone. We're starting the valedictory session downstairs. So if you could please make your way down. All keynote address by Professor Vish. Thank you.
I didn't know we held him captive here, so.